Okay, let me start by saying that it's a real pleasure, a real honor to have Professor Brian Leiter here with us at USP. And this initiative wouldn't have been possible without the generosity and help given by Professor André Freire from PUC. It's a very good example of how institutions can and should cooperate with each other in order to make events like this more often and take all we can get from it, even though sometimes tiring our invited guests. But I mean, thank you, André, and thank you again, Professor Leiter, for being with us. For those of you who are not fully acquainted with Leiter's work, I just would like to make some very few words. He's a very well-known, one of the leading philosophers in the Anglo-American world. He has written extensively on many different subjects. He has written on Nietzsche. He's a Nietzsche specialist. And he has also written on many different subjects, especially in legal theory. Some of his articles are, let's say, criticizing all the positions, as we are expecting him to talk more about today. But he's also the author of some original ideas, especially related to the let's say, Leiter's legal realism. So his own personal take on legal realism. So, and well, I don't want to spare the time that should be used by our guests. I just would like to say one other thing, which I think is very important, which is that some of the articles written by Brian Leiter are going to be published next year. And André Freire is the one responsible for translating them in Portuguese. And I think this is a wonderful opportunity for us to catch up with the current debate in legal theory and also to learn much with his thoughts. A final remark is that Brian Leiter is a very direct critic of his opponents of different ideas, as you might have noticed, simply noticing the title of his conference. And this also shows the openness of his, let's say, will to discuss and to have an open debate, which unfortunately is not that common in our Brazilian legal culture, but it's also an opportunity to learn more about how to discuss ideas. So I welcome you. Thank you very much for being with us, Professor Leiter.
Thank you, Professor Ronaldo. Is this close enough, do you think? Is it even on? It is on. Okay, good. Thank you. Well, thanks very much. I am very happy to be here. Professor Andre had told me that that at USP there were many fans of Ronald Dworkin. So I said, of course, I had to give a talk about why Dworkin was wrong about almost everything. I'm going to identify one or two things where I think he was right. Let me also say, I was discussing this with Professor Ronaldo the other night. He asked me about my colleague at University of Chicago, Richard Posner, who does sometimes write about legal philosophy. And Professor Ronaldo was wondering, what did I think of that stuff? And I said, oh, it's quite bad. He doesn't understand philosophy, but I don't write about that because he's not a worthy opponent. So I do consider Ronald Dworkin a worthy opponent, which is why he needs to be sliced and diced, as we say in English. So that it isn't, I choose him because he ought to be criticized. Okay. So what is Dworkin's theory of law? And now this will be quite familiar, of course, to some of you. Dworkin thinks that the law in a particular case, how should a judge decide a particular case? The law is what is entailed or follows from the best constructive interpretation of the institutional history of the legal system. Constructive interpretation, of course, is Dworkin's distinctive notion. what does Hercules, the ideal judge that Dworkin introduces, do? When confronted with a case, he asks the question, right, what moral principles, right, would fit or explain some portion of the institutional history of the legal system and provide the best moral justification of it. Okay? By the institutional history of the legal system, I just mean roughly what the legal positivist means by the law. Okay? So statutes, the code, in a common law system, precedents, constitution, executive orders. We have lots of them in the United States lately. Administrative rulings, all of this would be part of the institutional history. But crucially for Dworkin, that does not exhaust what the law is. What the law really is what follows from the constructive interpretation of all of these elements. Now, Dworkin also argues in his 1986 book, Law's Empire, that all interpretation is constructive interpretation. Nobody believes this. It's extremely implausible, and I don't think it much matters. What matters is whether in law, constructive interpretation plays the central role that Dworkin thinks it does. Now, let's say a little bit more about the elements of constructive interpretation. Hercules asked the question, right? We look at the institutional history of our legal system. We can see different provisions of the code and the Constitution. We could explain them as standing for certain kinds of moral principles. Principles of due process, of justice, of fairness, of equality, whatever the case might be. Dworkin recognizes that in any complex modern legal system, no single moral principle is going to explain everything in the institutional history. It's too big. There's too many different things going on. It's been created by too many people. Right? But we're looking for principles that have some sufficient amount of fit, as he calls it. He never tries to specify the exact amount because I don't think it would be plausible to say the principles have to explain 51% of the code, right? So he never says anything like that. But we can't just bring to bear a moral principle we happen to like if it doesn't actually fit some of what's come before, right? And this is partly why Dworkin calls his theory law as integrity, right? The idea is that the decision in this case should have some coherence with what has come before. In a way, Dworkin's theory is a sort of a very formal and explicit account of the intuitively plausible idea that like cases should be treated alike. To say like cases should be treated alike is to say when I go before the court, how I am treated should be similar to how other people similarly situated to me were treated. Right? So this is why we have the fit component of constructive interpretation. But since more than one moral principle will fit different parts of the institutional history of the legal system, we have to ask a question of justification. That is, the judge, according to Dworkin, should rely on the moral principle that fits. Of the moral principles that fit, the judge should rely on the moral principle that provides the best justification of our legal system from the standpoint of political morality, as Dworkin calls it. There are three relevant values in political morality. Right? One is procedural due process. It plays relatively little role in Dworkin's discussions, and I'm not going to say much about it. The second one is justice, and a third is fairness. And these are really the important elements of political morality that we need to take into account. So what do they mean? So Hercules, the ideal judge, okay, and of course he calls him Hercules for a reason because he knows no actual judge can do this. Hercules can survey the entire institutional history of the legal system. No ordinary judge has the time to do that in deciding any particular case. Right? So Hercules surveys the entire institutional history of the legal system, and he finds a number of moral principles that fit or explain different parts of the institutional history of the legal system. And then he asks the crucial question, right? Of these principles, which one provides the best moral justification in terms of justice and fairness? As I said, I put procedural due process to one side. Justice for Dworkin means what is really objectively just. Right? Doesn't mean what we happen to think is just. It's not a relativized, relativistic notion. It is what is truly objectively just. Dworkin's theory requires that there be objectively right answers to moral questions. Because there won't be a right answer to what the law is unless there is an objectively right answer to the question, which of these principles is really just? Now, from my point of view, I do not believe there are objectively right answers to moral questions. So this is already a serious problem from my point of view with Dworkin's approach. But I just want to emphasize he's committed to the idea that there are objectively right answers to the question, which of these principles is really more just? Fairness puts a constraint on Hercules in terms of choosing principles based on objective justice. Fairness for Dworkin is the idea that Hercules should be sensitive to the moral views of his community. You know? And sometimes if the objectively just principle is too different from anything recognized in the community as a moral principle, Hercules should prefer an objectively just principle, but not as objectively just as the first one. Right? So Hercules should not simply do what is truly objectively just. Hercules should choose a principle that is objectively just, right, but also is not totally foreign, totally unfamiliar to the members of his community. That's the fairness constraint, right? You might think of it as Hercules should not completely unsettle everyone's moral expectations about what the courts are going to do. So that's fairness and justice. Hercules decides which of the principles that fit are objectively the most just, but also satisfy the fairness requirement. And then Hercules finds a principle that satisfies those criteria and then decides the case before the court in a way that coheres with that principle. That's the principle that then informs the decision of the case before the court. All right. Dworkin has always acknowledged that it can be very controversial what justice or morality more generally requires. Indeed, it was one of his criticisms of Hart's view, H.L.A. Hart's view early on, that H.L.A. Hart could not allow that a rule of recognition could include moral criteria of legal validity because they would be too controversial. So Dworkin recognizes that people can disagree quite a lot about what is just, what is moral, what is morally right, even what is fair. So this can be very controversial. Dworkin's claim was never that we will always know with certainty what the law is in a particular case. His claim was that there always exists a right answer as a matter of law, the answer that follows from this procedure of constructive interpretation. So his thesis was a metaphysical thesis. There always exists a right answer as a matter of law. It is the answer that would follow from the procedure of constructive interpretation that I have just described. His was not an epistemological thesis. He did not claim we would necessarily know with certainty what that answer is. So there can be a very big gap between what we think we know. There could be a tremendous amount of disagreement about what the law is, but Dworkin says there exists a right answer, and the duty of the judge using the method of constructive interpretation is to try to discover this answer. Okay. Now, what's wrong with this view of the law. I want to juxtapose Dworkin's view, as Dworkin himself does, with the views of the English legal positivist H.L.A. Hart. I think one of Hart's most important insights about law is that law exists primarily outside the courts. It exists to guide people's conduct outside the courts. It is probably not irrelevant as a biographical fact that Hart was a tax lawyer before he became a teacher of legal philosophy. Okay? If you are a tax lawyer, right, your clients come to you not to end up in court. If you are a tax lawyer whose clients always end up in court, they will be very unhappy, right? They come to you because they want to know how to structure their affairs to lower their tax burden in a way that will not create a problem that generates litigation. But it's not just for the tax lawyer that this is an obvious point. Most people in the course of their life never go to court. When I hire a lawyer, when I purchased my home, the goal was to make sure that I actually had legal title to my home, right? To review the contract and the property documents to make sure that this was a sound transaction. When I had occasion to make a will, a testamento, as I have learned is the Portuguese word, when you go to make a will, the goal is not to end up in court. When I went to see a lawyer to make a will, I wanted to make sure that in accordance with the laws of Illinois, the state in which Chicago is located, and in accordance with the laws of Illinois, my property would be disposed of in accordance with my intentions upon my demise. Okay. Most of law functions that way. It functions to guide people's conduct, the conduct of businesses, right? Law exists primarily outside the courts, at least in a functioning legal system. If things are falling apart, everything is going to get adjudicated and litigated, and the courts will not be able to deal with it. I think that's a crucial fact about any functioning legal system, that law exists primarily outside the courts. And this is why what I like to call massive agreement about law is a very important feature of any functioning legal system. In a functioning legal system, there is a huge amount of agreement about what the law is. That is not true with cases that get into court, but it is true about the law as a whole. I give you an example from the American context, which I think illustrates this very nicely, though some of this applies more generally. Think of all the legal questions that arise in society. People go to their lawyer and they say, someone did this to me. Right? Do you think I have a legal claim? And most of the time, the lawyer can say, no, you have no legal claim whatsoever. You should go home. Right? It's clear. Everyone agrees what the law is. Or they say, actually, you do have a legal claim. Let me call up the lawyer for the other party. And most cases, right, end at that stage. They don't go a lot further than that. Why? Because there's massive agreement about what the law is. Some cases, right, actually litigation starts. One party sues another party. Now, here's what happens in the United States in civil cases. Criminal cases are different. So in civil cases, in litigation in the United States, each party has a right of discovery against the other party. You can compel the other party to disclose quite a lot. We have very extensive discovery in the United States, broader, I think, than most other jurisdictions. At the end of discovery, each party knows everything there is to know about what happened, right? And about the other party. In the United States, at that point, 95% of cases settle, which is really astonishing. In other words, only about 1 in 20 actually proceed to a trial. Now, why do they settle? Because there's massive agreement about what the law is, and the only uncertainty had been about what the facts were. And now everyone knows the facts. And so you can see what the law is going to dictate. And now you need to reach some kind of settlement, right? The party for whom the law is unfavorable, given all the facts, right, is going to have to pay something. And then the question will be, how much? Okay. Of the cases that go to trial, and by the way, not all cases that go to trial, of course, go to a verdict. It's a little complicated in the US because, as you may know, we rely entirely on juries made up of ordinary people. Parties can waive trial by an ordinary jury, but in general, almost all cases, civil and criminal, are tried by a jury. You may have recall one of Donald Trump is a serial criminal, so he violates the law continuously. But his criminal trial in New York last year was not a jury trial. They had agreed to waive the jury. Trump was going to take his chances with the judge. So because we use juries of ordinary people, sometimes the court at the end of the trial will direct a verdict. The judge will step in and say, given all the evidence, right, I don't want these ignorant, ordinary people to reach a verdict. I'm just going to tell you there's no other resolution that would be appropriate. You know? But so when you get to cases where there's actually a verdict at the trial level, right, it's already now a much smaller segment of all the legal questions that we had started with. Right? We get a verdict at the trial level, and now there's an appeal. Most cases do not get appealed. So in other words, the universe of legal questions is shrinking further and further. We start with the massive agreement. Massive agreement leads to settlement, right? We get verdicts, and we get even fewer appeals. Now, when we get to cases that get appealed, one factor that leads to the selection of cases for appeal, this is what we call a selection effect, is that parties are more likely to appeal cases where they think the law is actually unclear. Now we're in the realm of disagreement. People are not so sure about what the law is that governs this question. That's a good reason to appeal a case, because you might persuade the judges, the appellate judges, to agree with your interpretation of the law. And the higher up you go in the appellate process, the less representative the legal questions get. And the more we are in the domain of what H.L.A. Hart originally called hard cases. And of course, Dworkin adopted that label in an earlier statement of his theory in 1975. Okay. The basic fact, though, about a legal system is that there is massive agreement about what the law is. Cases that end up in the appellate courts are not representative of the legal system as a whole. They're unrepresentative, completely unrepresentative. Adjudication, right, on this view is a kind of marginal or fringe phenomenon in the legal system. It's only a very small part of all the legal questions that get asked and answered. And now you can see what I'm worried about in the case of Dworkin. He is focused on the most unrepresentative part of the legal system, appellate court decision-making, right? And he ignores the fact that there exists this massive agreement about what the law is. Now, it's more serious than that, right? Because Dworkin's theory can't explain the massive agreement about what the law is. Because if what the law is really does depend on considerations of justice and fairness, and justice and fairness, as Dworkin himself admits, can be controversial, then it seems like there should be disagreement all over the place. Because everyone could come up with their constructive interpretation and then disagree about it and so on, right? And so you wouldn't expect 95% of cases to settle after discovery is complete and all the facts are known. And indeed, anytime you go to your lawyer with a complaint, if your lawyer is a good Dworkinian, happily good lawyers are never good Dworkinians, but if your lawyer were a good Dworkinian, right, they would immediately say, aha, let me come up with a constructive interpretation of the institutional history of the legal system in which a principle that would lead to your victory will be the principle that both fits and justifies the institutional history of our legal system. But that's not what lawyers do. That is not what lawyers do. So Dworkin's theory can't even explain this basic fact about legal systems, that there's massive agreement, which means it can't really take account of the crucial fact about legal systems, which is that they guide conduct outside the courts. And they guide conducts not because everybody's doing constructive interpretation. Right? Nobody is. They guide conduct because people know what the law is. I think it is one of the virtues of H.L.A. Hart's theory of law that it can actually explain this. Because according to Hart, where a legal system exists, there exists a rule of recognition. And a rule of recognition is a conventional practice of officials and judges in the system that they converge on certain criteria of legal validity, and they take themselves to have an obligation to apply those criteria. And a good lawyer knows what the rule of recognition is, which is why they can answer questions about what the law is. The rule of recognition doesn't resolve every question. That's where we get cases that end up in appellate litigation. Okay? Now, do appellate judges use the method of constructive interpretation? No. Certainly in the United States, but I would think less so in a civil law country. But in the United States, in a common law country, where the law is largely made and developed by the courts over a period of time, first-year law students, right, are familiar with the following exercise. They are asked to read a series of cases on some question about contract law, say, and then they are asked the question, how do these cases fit together? Right? How are they consistent with each other? And that's a little bit like Dworkin's question, what principle would explain, fit this line of decision making? And I do think this is crucial in Dworkin's view, because Dworkin is trained as a common lawyer, and so he's familiar with this methodology. And I think this has a lot to do with why Dworkin resonates particularly with common lawyers, though I understand he's very popular here, but obviously for different reasons, because you don't have a common law system. So appellate judges, right? Appellate judges, to some extent, do ask the question of fit, okay, that Dworkin is talking about. It's not clear that they ask the question of justification, right? Or to the extent that they are asking it, right? They don't ask it openly, right? They ask it to themselves in a slightly different way. If the law is unsettled, if there's no answer in appellate cases, and as I said, because of the selection effect, the higher you go in the appellate process, the more likely it is that the cases don't have a clear legal answer. In those cases, as Hart would say, and as legal realists would say, judges are exercising discretion. They're making moral and political judgments, but they're making a moral and political judgment to fill the gap in the law, not by asking which of the principles that fit provides the best moral justification for the law. But I do think appellate judges all the time are doing that. I happened to read just the other day, prompted partly by a conversation about Richard Posner. Richard Posner was an appellate judge on the U.S. Court of Appeals, the Federal Court of Appeals that was located in Chicago. And when he retired, he was interviewed in the New York Times. As he got older, he became a little more candid about things than when he was younger. Right? But I think there's some truth to this. He was asked, well, how do you decide cases, right? How do you decide cases? And his response was in this interview, he says, don't tell me about the law, the statutes, the precedents, and so on. I want to know what happened. And I want to know what the sensible thing to do would be, right? And then I want to know if the law will let me do the sensible thing, okay? Where the sensible thing might be the fair thing, the just thing, the economically efficient thing, since Posner is a proponent of economic analysis of law. And I think for a lot of appellate judges, that's really what's going on. They aren't thinking in terms of the best moral justification of the institutional history of their legal system. They're thinking, given what happened in this case, what would be a fair or sensible or economically efficient result to reach, and then they turn to the law to see if it prevents them from reaching that particular decision. Okay? So I don't really think that appellate judges are generally engaged in what Dworkin calls constructive interpretation. I do think appellate judges, because cases are often legally indeterminate by the time they reach the stage of appellate review, I do think appellate judges must exercise moral, political, economic judgment to fill in the gaps that exist in the law. Wow. This is item number 4 on the handout, for those of you who have it. Now, students often wonder, why should we think there exists a right answer as a matter of law? That's Dworkin's metaphysical claim, when Dworkin admits we can't know with certainty what that answer is. And it's because we can't know with certainty what that answer is that I think Dworkin can't explain massive agreement about the law, as we were just discussing. But why should we think there still exists a right answer if very competent and skilled lawyers and judges disagree about what the law is? At one time, Dworkin used to lay emphasis on the fact that American and British judges, which was almost entirely his focus, 2 major common law systems, that American and British judges, when they resolve a hard or difficult case, they write their opinion as if there was a right answer as a matter of law that they have discovered. Appellate judges do not generally talk the way Richard Posner did in that interview. Appellate judges do not typically say, the law is unclear, there is no legally right answer, here's what I think would be a good resolution from a policy point of view. Here's what I think would be a good economic policy in a case like this. Here's what I think is the morally right thing to do. Judges generally do not say that. There are exceptions in common law jurisdictions. The Supreme Court of Australia for a very long time was dominated by former students of Julius Stone, a legal realist, and they wrote opinions like this. They were very candid to acknowledge that the cases that made it all the way to the Australian Supreme Court were cases where there wasn't a legally right answer. And therefore they said, we think a sensible way of resolving this would be to adopt this rule. Okay? So they were very open about it, but that was somewhat unusual. But early on, Dworkin points to the fact that appellate judges do not write as if they are exercising a discretion, that they are making a judgment based on non-legal considerations. And that, I think, is generally true. Of course, that's not very strong evidence for Dworkin's thesis, unless you, as it were, from my point of view, are a bit naive. If you think that everything judges say in their opinions represents what judges are really thinking, then you don't understand what's going on, okay? That's with my legal realist hat on. And that's what Richard Posner would say as well. And in the United States, clearly true. But Dworkin had, I think, a stronger and more important argument for his right answer thesis, for his thesis that even when we disagree, there is still a right answer as a matter of law, right? Which is, Dworkin said that we need an account of law. We need a theory of law that would explain why the exercise of coercive power by the courts would be morally justified. Right? Now remember, courts do exercise the coercive power of the state. Right? Losing parties can be put in jail. That's very substantial coercion. Right? They can have their property seized. They can have their income garnished by the court. Right? So the courts exercise the coercive power of the state. And Dworkin says a theory of law should explain why, when courts exercise their power in accordance with law, that is morally justified. Now, Dworkin, in his book Law's Empire, describes this assumption for what a theory of law must do. He says it's uncontroversial. It's page 93 of Law's Empire. It is not uncontroversial. Nobody believes it. Nobody prior to Dworkin believed it. Hans Kelsen didn't believe, right, that the exercise of coercive power by courts had to be shown to be morally justified. H.L.A. Hart didn't believe it. Norberto Bobbio didn't believe it. Alf Ross didn't believe it. So it's not uncontroversial at all. Right? It's a very, very powerful and implausible, it seems to me, assumption to build into an account of the nature of law. It's a perfectly good question of moral and political philosophy to say, when are courts morally justified in exercising coercive power? That's a good question to ask, but it's a different question from asking what is law, right? And courts may exercise coercive power in accordance with law, and it may be very unjust, and it may not be morally justified. But Dworkin thinks the theory of law has to explain why it is morally justified. Now, on Dworkin's view, and this explains the right answer thesis, the exercise of coercive power by courts will be morally justified if they use the method of constructive interpretation, because then law will exemplify the virtue he calls integrity. That is, everyone will be treated in a principled and coherent way with everyone else. Right? We stand in a kind of equality before the law in the sense that our treatment by the law is governed by moral principles, right, that are the same ones, more or less, that govern the treatment of everyone else. This is the virtue he calls integrity. And then he argues, and I'm not going to talk much about this because I think it's a very implausible argument. Almost nobody has this view of moral obligation to obey the law. He says there's a kind of obligation that he calls an associative obligation. An associative obligation is where we have obligations to do things, not because of our voluntary consent, not because we agreed to do something or promised to do something. We have an obligation just because of the association, the relationship we stand into other people. The best example of that is the family. Okay? I didn't choose my parents. Right? I didn't choose my children. I chose to have children. That's different. But I didn't choose to have the particular children that I have. Okay. Yet it's natural to think you have obligations to your parents and obligations to your children. These are examples of associative obligations. And Dworkin's claim, okay, now it's a little more complicated than this, and if someone wants to talk more about it, I'm happy to do so. But Dworkin's claim is that when a legal system exemplifies integrity, we are all like a big family. Right? We now stand in an association with each other that generates an obligation to obey the law. The problem is, of course, that the intuitive appeal of associative obligations, that you have an obligation, gets weaker the more tenuous, the weaker the connections get between people. Right? And the idea that I have an associative obligation to obey the law in a country of 340 million people, or in a country of 240 million in Brazil? 210 million. That somehow we're all a big family because the law treats us with integrity seems to be somewhat incredible. Okay, but that's the connection for Dworkin, right? So law's integrity requires that there exists the right answer as a matter of law, because constructive interpretation is all about discovering that right answer. And only if judges are trying to do that can the legal system exemplify integrity, which would explain why courts are morally justified in coercing the losing party. Because even the losing party has an associative obligation to obey the law. Yeah. Now, there's other things that Dworkin is wrong about that I haven't talked about. I think his treatment and misrepresentations of H.L.A. Hart over decades are really scandalous. In normal parts of philosophy, this would not stand. That is, someone who misrepresented their main opponent so badly for so long would have been discredited. This has not happened, obviously, in legal philosophy. And there's a lot of things we could go through. Contrary to Dworkin, H.L.A. Hart did not think law included only rules and not what Dworkin calls principles. That's just false. Contrary to Dworkin, Hart did not think that a rule of recognition can only include what Dworkin calls pedigree criteria of legal validity. That is, criteria of the form, this norm is legally valid because of its source, because of where it came. Sorry, I lost my place in my own outline here. Well, I can talk more about that, but I think even many defenders of Dworkin, I think probably also Professor Ronaldo will acknowledge that Dworkin was not always the best guide to what his opponents actually thought. Let's just leave it at that. All right, let's go to a more interesting question. What was Dworkin right about? Since he's wrong about what appellate courts do, he's wrong about the nature of law, which exists mainly outside of courts, which he can't explain. But as I say, he was wrong about almost everything. Okay, he was right about some things. One thing he was right about clearly, and Hart admitted this, was that when H.L.A. Hart wrote the concept of law, he made it sound as if you can never speak of someone having an obligation unless there exists a social rule. Right? Let me just remind you about Hart's idea of a social rule, one of the crucial ideas in the concept of law. Hart says often people engage in convergent patterns of behavior, lots of people doing the same thing. Right? Probably everyone in the room has a cell phone. There's a convergent pattern of behavior. Right? But there isn't a social rule that you ought to carry a cell phone, right? That is, if you didn't have a cell phone with you, people probably wouldn't criticize you. They might be surprised, but it's not like it would be wrong not to have a cell phone with you. There's no obligation to carry a cell phone. It's just a habit. It's a habit we all share of having a cell phone. A social rule exists, according to Hart, when people not only do the same thing, they converge in their behavior, but they have a certain attitude towards the behavior. They think they ought to engage in this behavior, that it is the right thing to do, that it would be wrong not to do it. And we have lots of examples of social rules. Some of them are legal rules. Right? The rule that you stop at a red light is a legal rule. It also happens to be a social rule. That is, if you stop at the red light and your passenger says, "Why did you stop?" Right? You say, "Because I have to stop when the light is red." That's the rule. And if someone drives through the red light, other people criticize them. Say, "Look at that terrible driver, just broke the law." Hart's claim is not that all legal rules are social rules, though some are. Hart's crucial claim was that the rule of recognition is a social rule. It is the social rule that consists of the criteria of legal validity that officials converge upon and that they view as obligatory, that they accept from an internal point of view, is Hart's term for it. They think we ought to apply these criteria of legal validity. But Dworkin makes, I think, the correct point in the model of rules too, that not every case in which we talk about an obligation or a duty to do something presupposes the existence of a social rule. When slavery existed, my country, like yours, had chattel slavery for a very long time. And in the US, and I'm sure here too, there were abolitionists who called for the abolition of slavery. They said it was morally wrong to enslave people. I gather this is part of why the Jesuits got thrown out of the country, is they did tend to insist that slaves were human beings too, who had moral rights and equal standing before God. An abolitionist during the time of slavery says, slavery is morally wrong. You have an obligation, a moral obligation to free your slaves. They weren't presupposing there was a social rule. There wasn't. That was the problem. But we understand what the abolitionist is saying. His claim that there's a moral obligation to free human beings from chattel slavery, perfectly intelligible without the existence of a social rule. And I think Dworkin was completely right about this, and Hart conceded this particular point. The thing is, Hart doesn't need that claim. It was a mistake in the concept of law to leave that impression. It's still the case that the notion of a social rule is very useful, and it's very useful for explaining legal systems and for explaining the phenomenon of a rule of recognition. So Dworkin's correct, but I don't think it affects the major points of contention between Dworkin and Hart. The other issue he was right to identify is the phenomenon that he referred to as theoretical disagreements. So Dworkin distinguished between disagreements judges might have, right, about how the law applies to a particular set of facts, right, or disagreements in which judges agree what the criteria of legal validity are. All the judges agree the intention of the legislature should control the interpretation of the code or a statute. But then they disagree what the intention is. That's an empirical disagreement, according to Dworkin. But Dworkin says it's a different kind of disagreement that he calls a theoretical disagreement. And this is where judges disagree about what the criteria of legal validity are. Dworkin says the grounds of law. I'm just not going to use his terminology. I can talk about why if people are interested. What happens when judges disagree about the criteria of legal validity? Right. I think what determines the content of law is the intention of the legislature. My fellow judge thinks what determines the content of the law is the plain meaning of the text of the code. Now we have a theoretical disagreement in Dworkin's sense. We disagree about what the criteria of legal validity are. And Dworkin claims in Law's Empire, legal positivism, he says, cannot explain theoretical disagreements, and therefore it's a failure as a theory of law. Now, the conclusion is a non sequitur. Right? A theoretical disagreement is a phenomenon. We can ask what the explanation for that phenomenon is, but it's not the only phenomenon related to law we're trying to explain. I think a far more important phenomenon is massive agreement about what the law is, which is the norm in a functioning legal system. And as I said, Dworkin's theory can't explain that. But Dworkin does raise a fair question. What should the legal positivist say about a theoretical disagreement? And the reason it seems to be a problem for the legal positivist, like H.L.A. Hart, it's not clear to me Dworkin ever read Kelsen, to be perfectly honest. So Hart is his representative for legal positive. Hart, of course, read Kelsen very carefully and was quite influenced by him and also had some strong disagreements with him. What does the legal positivist say about a theoretical disagreement? Well, what are the criteria of legal validity in the rule of recognition? They are just the criteria that judges converge upon and accept from an internal point of view. So it looks like if you want to resolve a theoretical disagreement, you just have to count heads, right? How many judges actually utilize this criterion and how many don't utilize this criterion of legal validity? So if we want to know, is the law what the legislature intended or the plain meaning of the code, we need to see how many judges use plain meaning, how many judges use the intention of the legislature. And Dworkin says that's not how judges talk about these problems. And that's correct, right? Judges do not try to resolve a theoretical disagreement by saying, I'm right, because most of the judges interpret the code the way I do. They don't argue that way. So Dworkin was correct about that. I think the crucial question, though, for Dworkin is how many theoretical disagreements are there really? And I think there are, in a functioning legal system, relatively few. Where do they occur? In the appellate courts, and especially the highest, the Supreme Courts. In your case, the Supreme Court and the Superior Court. In the US, we just have a single Supreme Court. You do get theoretical disagreements there. And judges sometimes write their opinions as if there is a fact about what the criterion of legal validity is. And my view is they're wrong a lot of the time. There just isn't. And I think there's lots of easy explanations for why judges are disingenuous, right? Why they might not be candid about what's really happening in these cases. If judges of the United States Supreme Court said, the reason we are overruling Roe versus Wade and finding that there is no constitutional right of the woman to choose abortion is because 6 of us were brought up in conservative Catholic homes, there would have been an uproar, though that is the actual explanation for the decision. But they didn't write it that way. But it's easy to see why they didn't write it that way. It would create a political crisis, you know, it would undermine legitimacy of the court and so on. So I don't mind saying that sometimes judges do write as if there is a right answer to a theoretical disagreement when there isn't really. And I think it's easy to explain why they sometimes do that. So Dworkin's real objection to the legal positivist is that they cannot explain the surface, the face value of the disagreement. They have to explain it away. They have to say it involves a mistake or a misunderstanding. But I want to say in many different domains, the best explanation of what people say is not to take seriously what they say at face value. Take Donald Trump. Right? Someone who thought the best explanation of what Donald Trump says is to take seriously the meaning of the words, right, would be making a mistake, because Donald Trump is a pathological liar, and he says things for instrumental reasons that have nothing to do, right, with taking seriously the face value of what he says. That's an extreme example. I don't think the courts are like that generally, but I do think that highest appellate courts are often not very honest or candid. And sometimes I think the judges make honest mistakes. Sometimes the judges honestly believe that they know what the correct criterion of legal validity is, right, when there in fact is no convergence in the rule of recognition on that particular criterion. And from my point of view, their mistake is they don't understand the truth of legal positivism. And if they understood the correctness of legal positivism, then they would realize that sometimes they get cases where there is no right answer because there is no agreement on the relevant criterion of legal validity. All right, a final point. Number 6 on the handout. Okay. So if Dworkin is this bad, as I've tried to argue, his theory is this inadequate and unsatisfying, why is he so popular? Now, I can't speak to why he's so popular here, though I've been learning a little bit about it. But I can tell you why he's so popular in the United States. The first thing to say is that it's not his actual theory that is very popular, because even, especially constitutional law professors who are his biggest fans in the United States, in constitutional law professors often don't actually understand the theory. I've noticed this over the years because I ask questions and they aren't aware of, they don't understand the full method of constructive interpretation. They don't understand the implications of the justification for it, so on. What do they like about Dworkin? They like that Dworkin is the guy who says courts should be taking into account moral considerations in deciding difficult constitutional questions. That's what they like. That, of course, is what the Warren Court in the United States in the 50s and 60s did a lot, okay? Which is when Dworkin first started writing. And a lot of constitutional law professors in the United States worship the Warren Court. And they think Dworkin is the guy who tells us why it was correct to take into account justice and fairness and equality in resolving difficult legal questions. That's why they like Dworkin. The problem is, everyone agrees, legal positivists, legal realists agree, that in difficult constitutional cases, in difficult legal cases, judges should take into account relevant moral considerations. Judges should try to act morally just like we hope everyone else should try to act morally. Not that most people do, but that's a different matter. But we hope that they will, right? So of course judges should take into account moral considerations, right? But that's different from saying that they, in doing that, they're just discovering what the law is. What they're actually doing is exercising discretion, because the law has run out. That's why these cases get to the Supreme Court. Sometimes cases get to the Supreme Court because the Supreme Court wants to make new law, and they invoke a moral principle, or they rely on one quietly in order to change the law. But most often it's to fill in gaps in the law, because appellate courts get cases where the law is more likely to be indeterminate. So now the only difference is that Dworkin says when judges do this, there's only one right answer as a matter of law. Right? And that answer, and that when you take into account moral considerations, moral principles, that's part of the law too. And that's what the positivist and the legal realist denies. But that, I think, is why Dworkin is very popular in the United States. It's what I call Dworkin Light. You know, in the US, we have Coke Light. Here, Coca-Cola Light, I've seen it around here. Pepsi Black, right? It's Dworkin Black. It's Dworkin without the sugar, where the sugar is really all the details of the theory. It's just this very simple idea that I think is very appealing to American constitutional lawyers who grew up with the Warren Court. So that's why I think he's popular. I don't think it's because most people actually study or understand his theory very clearly. All right, I'll stop on that point, and I will welcome your defense of Professor Dworkin against my criticisms. Thank you.
Thank you, Professor Leiter. It was a privilege to listen to you. I think I'll start by taking a risky strategy, which is to make some comments before opening the discussion to the floor. And it is on one hand a claim for more clarification, but also a claim against some of your statements about which I would like to hear more. So the first statement that you made, that according to Dworkin, all interpretation is constructive interpretation. I think it's a misstatement, because I think that Dworkin never said that all interpretation is constructive interpretation. He said in many places that there are many different kinds of interpretation, and he never denied that these other kinds of interpretation could be very useful for and very, let's say, common in legal practice, like conversational interpretation, literal interpretation, whatever. So, but he says that there is a special kind of interpretation, constructive interpretation, that has been neglected. So it is more modest, let's say, claim that he makes, according to my view. Second point is that I think that legal, you said that for him, legal interpretation is constructive interpretation. I don't think this is right too. I mean, what he says that sometimes the constructive interpretation is unavoidable. But he doesn't even say that the practice of law is always interpretive. This is a claim that was assigned to him by, for example, Dennis Patterson, who says that it was a mistake made by Dworkin to say that we always need interpretation in order to practice the law. I don't think that when we stop at a traffic light, we need to interpret the traffic light. And I don't think that Dworkin makes the same mistake either. So I think that, well, what he's claiming is that there are many different kinds of interpretation. There is a family resemblance among them, but there is a special kind of constructive interpretation that is important and which has been neglected. The third point is that I think that the description that you made about the concept of fit tends to give, let's say, an exclusive empirical meaning to it, because in many passages, I think, Dworkin says that the fit is not connected with the practice, the crude practice itself, but it's the fit with the evaluative appeal of the practice. This is a point that has been stressed, according to my view, correctly by Gerald Postema in his writings and interpretation of Dworkin. I also think that, well, to say that I fully agree that, and you mentioned this, made a lot of illustrations that, well, law is, what happens in the court is just the top of the iceberg in terms of the legal practice. And I think this is right. And I think that Dworkin doesn't deny that by no means. He mentions even in Law's Empire that law is constituted by institutional practices. But I think that he says there that there is a part of law which is not directly or exclusively institutional that has been neglected. So I agree with you. He puts a focus, some light on this non-exclusively institutional dimension. But to say this, it's not to say that either law is always interpretive, and not to say either that law, a correct understanding of law can be taken looking exclusively on what happens inside courts. His claim, I think, it's more modest. It's just to say, well, legal theorists have neglected a more in-depth account of what happens in courts. And this is part of law. Even though I think he could agree with the claim you assign to Hart, that law is primarily institutional. But to say that it's primarily, it is not to deny that there's a part of it that doesn't fit fully in this description. It would be very much like saying mammals are animals that feed the offspring with milk. Well, but then you find a platypus, and then you cannot kill the platypus just because your previous understanding of what, in the majority of cases, are mammals doesn't really fit. So I think that he wouldn't deny this. And later in his work, he said that, well, there is a kind of sociological understanding that is basically institutional. I think this is the kind of concept that sociologists usually use in their research. There's nothing wrong in using this way. However, what he's trying to say is that when you say this, neglecting what happens in courts, and especially neglecting the kind of arguments, not that are only empirically made, but the kind of reasoning that affects their behavior, which is their claim about the existence of some kind of rationality on what they're doing, you are missing something that is very important. There's a kind of blind spot in traditional legal theory for not acknowledging this. So I think again, it's a kind of more modest claim, more challenging to defy, I think. Sure.
Could I respond to some of these?
Yeah,
because you raise a lot of interesting issues. And I think you are giving a constructive interpretation of Dworkin. You are trying to show him in his best light.
Yeah.
I agree with some of it, but I disagree pretty strongly with other parts.
Quinian with charity.
Well, I have never before heard anyone say Dworkin's claim is modest.
Yeah.
Modesty is not what comes forth from the text. And I also think it's just incorrect. It's not that he's acknowledging Hart's point. I don't think there's anywhere where he acknowledges the point that law exists primarily outside of courts. Saying it's institutional, he has to say it because constructing interpretation is interpretation of the various institutional acts. His claim was more modest in 1975. In 1970, Dworkin in 1975, I think, would fit what you are saying, because in 1975, in the paper in Hard Cases, he's concerned only with the question whether in difficult cases, like cases that get to the Supreme Court, judges are exercising discretion or whether there's still a methodology they can use to discover what the law is. Okay? That's a more modest claim. The modest claim is thrown out the window in Law's Empire. All law is constructive interpretation. That's the thesis of the book, right? Now, we'd have to, now I'm going to come to your other point here, but the claim is that even easy cases involve constructive interpretation. It's just very easy, right? It's, we get there very quickly. We don't need to spell it out and so on. What law is what follows from the constructive interpretation of the best institutional history of the legal system. That's the view that Law's Empire sets out to defend. So it is not modest in the way I agree with you. The 1975 thesis is modest. There's probably some ambiguity in the use of the word interpretation in the way I was using it that your comments are picking up on. Dworkin's claim in the early part of the book is that all interpretation of texts and of artworks is constructive interpretation. It's a very, very strong claim. Right? He thinks the claim gets some support from Gadamer, Gadamer's hermeneutics. Since Dworkin doesn't know any history of thought, he doesn't know that there's an earlier tradition of hermeneutics to which Gadamer is opposed. And in between, from Schleiermacher to Gadamer, I think Schleiermacher wins the debate hands down. That's a separate issue. Okay? But he wants to make the very strong claim that when you interpret a novel, when you interpret an artwork, right, you are engaged in a constructive interpretation. I agree with you if you want to say that every act of understanding is an act of interpretation. I interpret what you're saying. I'm inclined to think I don't really interpret. I understand what you're saying, but there's no interpretation, no extra bit I've got to do. So I didn't want to include that, but that's the ambiguity of interpretation. So I think we don't actually disagree about that at the end. But the way I put it was ambiguous between the different senses of interpretation. I do think he believes all legal interpretation by officials is constructive interpretation. I agree with you that when I stop at the red light, I'm not doing any interpretation. I just have learned that I need to stop at the red light. So that's certainly not an issue for Dworkin. But I do think it follows from Dworkin's view that if you consult a lawyer about what the law is, the lawyer ought to be able to do constructive interpretation. And certainly when you go before a judge, the judge is supposed to be doing constructive interpretation, even if they don't do it as explicitly or as well as Hercules. Right? What Dworkin says later in Law's Empire is Hercules' way of deciding cases, constructive interpretation, captures the underlying logic of ordinary judicial decision. That's the claim. He understands real judges can't and don't do what Hercules does. Now, on the question of fit, you say, and you know, this is a tricky question. We'd have to open up the text and look at particular things he says. And you mentioned Posthuma's different reading of it, where the fit question is not just what moral principles explain the decisions, but also we're trying to fit the evaluative appeal of the practices, of the legal practices. Maybe that's a correct reading. As I say, we'd have to look at the text. I'm not sure it's a reading that does Dworkin any favors for the following reason. Constructive interpretation is supposed to be interpretive, right? If evaluative judgments are sneaking into the fit part, then it starts to get a little closer to being construction all the way down. Because remember, Dworkin's theory is not Hercules should decide the case in accordance with the most just principle. That's not interpretation. That's just construction. If we get evaluative considerations into the fit component of constructive interpretation, we risk losing the interpretation unless there's some way to limit right, the importance of these so-called evaluative appeal or evaluative point of the practice. So I'm going to be agnostic on the question whether that's the best reading of Dworkin. I'm inclined to think, as a constructive interpretation of Dworkin, it's going to create problems for him in terms of preserving the idea that constructive interpretation includes interpretation. By the way, John Gardner once wrote a paper that was a constructive interpretation of Dworkin. He said the best constructive interpretation of Dworkin shows him to be a legal positivist. And Dworkin, in his usual generous fashion, reacted very badly to that suggestion.
Can imagine. So just to pick
And
up.
I'm sure you have other points, but
No,
I thought before we had too many on the table.
Yeah, I don't want to monopolize, just to say, but just a kind of follow-up from what you said at the end. So you are dismissing the very idea of the possibility of some kind of hermeneutical circle, which lies behind on this critique of a final empirical foundationalism that I think you
Right.
were.
I mean, I do think Gadamer is wrong about interpretation in very fundamental ways.
Okay. I'll have many other questions, but I don't want to be egoist. So Daniel, if you could, would you like to wrap some 3 questions and then reply to it, or maybe you can stop whenever you
I
have.
should reply to each question.
Okay.
It never works to have multiple questions, then
Okay,
people
okay,
forget the
okay.
original one.
Okay, so Daniel, and then raise your hands and I'll try to pick it. Yeah, please use the
Yes,
the mic,
right, because
because
this
we are
is being
recording.
recorded. Dworkin's family asked to have a recording of this. That's a joke.
All right. Many thanks, Professor, for the lecture. So my question is actually, I would like to listen a bit more about the following idea I had while listening to your talk and reading your stuff. Sometimes Dworkin, and I'm not sure if this is a criticism of Dworkin or defense of him. Sometimes I think that Dworkin gives this impression that we can see that on chapter 3 of Law's Empire, you can see that some other places as well. And just for hedgehogs, that when he talks about interpretation, he's not talking constructive interpretation. He's not talking about what judges are doing when they're judging cases. Rather, he's talking about how can judges justify what they did. So this is a bit different, I think. Sometimes, because when, let's say, I decide something in my life, the way I did that might be a causal explainer for some reasons, but when I try to justify that, that's a different matter. And sometimes the way that Dworkin talks suggests the second, the idea that he's trying to justify that. For instance, in Just for Hedgehogs, he mentions that, well, if a judge somehow admits that there might be 2 different answers to that case, but that the judge decides to send you to jail anyway, then this judge should actually be the one going to jail. So it gives this impression that it's about justification. However, and that's why I'm not sure if this is a defense or not of Dworkin. I don't think it is. However, if this is the case, then Dworkin is actually playing American football while everyone else is playing the true football, which means he's talking about a political theory of education and then not about the nature of law, which actually, so there are 2 different games here, and he kind of might have missed the place he's playing. So I would like to listen a bit more on that point.
Okay, that's interesting. I mean, I think I do agree with your second point that the question about what would justify, how judges could justify their decisions and their exercise of course of power is a different question than the question about the nature of law. So I agree about that. You know, on this interpretive question, I've not read Justice for Hedgehogs. Life is too short. I've read enough Dworkin at this point. But in Law's Empire, you know, as I mentioned just now in response to Professor Ronaldo, the Dworkin does say, I mean, he's very clear. He's always very clear that no real judge is Hercules. Now, Hercules uses the method of constructive interpretation, but it's such a complicated method, it demands so much that only a Hercules could do it. And then he says in Law's Empire, very late in the book, he says, the way Hercules decides cases captures the underlying logic of the decision, right? So not what the decisions they explicitly write, but this is the esprit, this is the spirit of what they're trying to do. And that in a way would fit with saying that this would allow judges to answer the question how they can justify their decision. And if justify here means shows how the exercise of coercive power is morally justified, right? Then I agree with you, that's a completely separate question. And nobody in the history of 20th century jurisprudence before Dworkin thought that was a constraint on saying what the nature of law was. Thanks.
Please try to be short and say your name before making the question.
Hi, my name is Renato. Hi, Professor Leiter, Professor Ronaldo, Professor Andre. Thank you for this opportunity. On a somewhat recent paper, Professor Leiter, called Back to Heart, you talk about the rule of recognition, and you talk about the idea of the rule of recognition only specifying valid sources of law. And that would be a different question from how these sources are to be interpreted and applied. And you point out a difficulty to this view that in that the rule of recognition should fulfill an epistemic function. So you have to know more about the sources.
Right.
I was wondering if, since this paper came out, if you have evolved on these ideas of the rule of recognition as identifying only the sources of law and on this divide between interpreting and applying. Thank you.
Good. Right. So some legal positivists have responded to Dworkin's theoretical disagreement objection by saying that the rule of recognition only requires convergence on the sources of law, not how to interpret the sources. And all of Dworkin's examples of theoretical disagreements are disagreements about how to interpret them. My example was, do you interpret the code in accordance with the plain meaning of the words or the intention of the legislature? Right? And some legal positivists say how you interpret sources is not part of the rule of recognition. And Hart says very, very little about interpretation of sources, right? In the Italian legal philosophical traditions, they distinguish very strictly between the sources and the interpretation. And of course, that would be an easy response to Dworkin. But here again, I think Dworkin is right. That is, I do think the rule of recognition, Hart's idea of rule of recognition, cannot be silent entirely on the question of interpretation. And so my view is still the same from this paper that you referenced from a few years ago. And the reason is because a rule of recognition fulfills an epistemic function. It is, after all, that's what recognition is. To recognize something is to know it, okay? The rule of recognition has to enable us to know what the law is in many, many cases to fulfill its epistemic function. Not all cases, but many cases. And I can't see how the rule of recognition can fulfill its epistemic function without some claims about how sources are to be read. Okay? Now, some claims about how sources are to be interpreted are claims purely about other sources. Right? So in the American system, the Supreme Court gets to say what the Constitution means. As we were discussing yesterday, that may change under Donald Trump. But for the last 70 years, it's been pretty well settled that the Supreme Court's interpretation of the Constitution is what the Constitution means. And that settles a lot of questions of interpretation. The Supreme Court held in 2005 that it is unconstitutional to execute juveniles. Unconstitutional to execute juveniles. It violates the 8th Amendment prohibition on cruel and unusual punishment. If all you knew was the 8th Amendment prohibition on cruel and unusual punishment, is it unconstitutional to execute a juvenile? You might think it's unconstitutional to execute anyone. Right? You might think execution is cruel. And the Supreme Court has settled it. Everybody now knows. Any state governor, even in benighted states like Texas, is thinking about executing some juveniles, the Attorney General will say, Governor, the Supreme Court said we can't do this. Right? They're going to block it. Right? Now we know how to interpret it in a case involving juvenile. But I think we need more than that. We do need, as it were, some convergence on interpretive canons. And in many jurisdictions, less so in the United States, but in many jurisdictions, I think there does tend to be convergence among judges, but there's a lot of variation between different jurisdictions. We don't necessarily need all canons of interpretation in the rule of recognition, but we certainly need some. We need to know, for example, that as a starting point, all law is written down in the natural language of the community. That's our starting point. Right? If there's a doctrine of precedent, as there is in my country, then we need to know that courts can settle the meaning of terms. We need to know something about, there's big difference between intentionalism and what we call textualism in statutory interpretation. Textualism is now dominant in the US federal courts. That wasn't true when Carl Llewellyn wrote his famous paper in 1950 on the theory of appellate adjudication. Right? But now there is convergence on textualism. Originalism in constitutional interpretation. The Constitution should be interpreted in accordance with the original public meaning. When the late Antonin Scalia introduced that idea, nobody agreed with him, but he always insisted it was right. Now, there is some convergence developing. It may yet become the law of the United States that what the Constitution means is what the original public meaning of the words is. And then we're all screwed in America. But we haven't gotten there yet. Mayhem. Thank you.
Other questions? Other questions? Alberto.
Thank you very much. Let me to take my eyes to a different point, to one specific object of the Dworkin's undertaking, international law. How do you view the Dworkin's attempt to reconceptualize international law on the basis of salience principle?
Well, I'm going to have to disappoint you because I haven't really thought much about Dworkin's theory of international law. So I have nothing that would be of any value to say about it. So I apologize.
Outras questões? Yeah, please.
Hi, Professor. I'm Guilherme. Thank you for a lecture. Could you please expand on the idea that massive agreement cannot have a place inside an idea of law that is determined by justice? You said right in the beginning of the lecture that if justice cannot produce consensus, and you have an experience of the phenomenon of law that involves massive agreement, so that cannot be that a massive agreement can come from the idea of justice as directive of interpretation inside law. Could you please expand on it? Thank
Okay.
you.
Yeah, good. Thank you. Okay, think of it this way. Again, I'm going to have to use the United States as the example because that's the legal system and the culture that I know well. But I suspect something similar is true in Brazil. I'm quite sure there is massive agreement about what the law is in the United States. I'm also quite sure there's massive disagreement about what justice is. All right. Some people think that justice requires the consideration of race in the admission of students to universities. Other people think that's the paradigm of injustice, right? Some people think that justice would require either the elimination of capitalist markets in favor of socialism or the massive redistribution of wealth, right, in order to have a just society. Other people think that would be the paradigm of injustice, that justice is a matter of respecting individual property rights, however the distribution turns out. Some people think it's a requirement of justice that we have secure borders and that anyone who didn't come into the country illegally immediately be deported, even if they've been in the country for years. Other people think that would be extremely unjust and unfair. Okay? That's just 3 examples. Okay? If what the law is really turns on considerations of justice, and people disagree about what's just as much as they do in the examples I've just given, it would be very surprising that there would be massive agreement about what the law is. Right? Disagreement about justice, as ill-informed as one may think some of it is all over the place. More so than there is disagreement about what the law is, which is why you can go to almost any lawyer who drafts wills in the city of Chicago and get a perfectly competent will. So that's what I had in mind. I think it's not on.
Hi, Professor. Thank you for your words. I've read a lot of your texts during the SJD, and I would like to ask you something. In one of your texts, you mentioned that Dworkin's some sort of sophisticated formalist.
Yeah.
And in one point you say, well, one of the ways to distinguish formalists to realists is because formalists use mostly legal reasons to decide cases, and realists non-legal reasons like underlying facts of the case. So, and Dworkin uses the right answer. So what makes someone denies that when you choose a political criteria to find objective the reasons for deciding a case, they are not exercising discretion. And when they consider the underlying facts of the case, the consequences of deciding one way or another, they are exercising unjustified discretion. So,
Okay, I think I understand. I don't want to say it's unjustified, the discretion. One of the reasons I think legal realists have to be legal positivists is because the legal realists think that judges are influenced by non-legal considerations, including moral and political consideration. And if they weren't legal positivists, right, that distinction wouldn't make sense. Because Dworkin, of course, thinks judges should be taking into account moral considerations because they're part of the law, right? Because they're actually part of what I call the class of legal reasons, the reasons that a judge should be considering to justify their decision. So let me think of a good. I give an example from American legal realism, which I actually discussed yesterday, but it's a particularly good example for this purpose. This is due to a man named Herman Oliphant. Herman Oliphant studies a bunch of contract cases in which one party has made a contractual promise not to compete with the other party. And sometimes courts enforce the promise, sometimes they strike it down. And the reasons of contract law they give make no sense. They don't explain the difference between the cases. Right? Here they say no consideration, implied mistake, implied condition. There's no rhyme or reason to it. Oliphant says, let's look at the underlying facts of these cases. In all the cases where the courts find a reason to invalidate the contract and strike down the promise, it is a promise by an employee to a seller of the business, an employee to their employer, not to compete with the employer after taking another job. Okay? So I join your bakery. I promise after you train me as a baker, I'm not going to set up my own bake shop and then compete with you. Courts always strike that down. Now, why do they strike it down? Well, basically because they think it's unfair. Right? They think it's unfair. Employees have less bargaining power. Employers have more bargaining power. So it's very unfair. So they just get rid of them. Now, notice if the reason they're getting rid of them is unfairness, it becomes a question, is unfairness part of the law? Is unfairness a legally binding consideration for the court? Well, in a Dworkinian theory, it could be, right? It could be. Dworkin might look at Oliphant's case and say the judges are doing constructive interpretation. Okay? And they didn't articulate it fully, but that's what they're doing. Constructive interpretation. The unfairness of these contracts is a relevant consideration to whether they are legally valid contracts. And this is not discretion. This is just finding the right answer that the law requires. But that's not how the legal realists view it, right? Because they are implicitly legal positivists. They think that because the consideration of unfairness doesn't have any source in the law, there's no statute, there's no prior case, there's no constitutional provision that says unfairness of contracts means they're not valid. Therefore, it's an exercise of discretion. Which is why I think the legal realists have to be legal positivists, right? But you could reinterpret a lot of the realist examples in Dworkinian terms, and then they are just doing formalistic decisions, but in my special sense of formalism, right? And that's where you started, what I called sophisticated formalism, because formalism, certainly in the United States, I don't know if this is true here, is often used as a term of abuse. It's a criticism. The court's decision was formalistic. They ignored relevant factors. They just followed the rules kind of stupidly. Okay. That's not what I mean. Formalism is sometimes thought to mean that judicial decision-making is mechanical. It's like you feed the law and the facts in and the computer spits out the answer. No, that's not what I mean. Sophisticated formalists like Dworkin thinks there exists a right answer as a matter of law in every case. It could be controversial what that answer is, so it's not mechanical at all. But there is a right answer, and there is a method of legal reasoning that's supposed to get you to that right answer, the method of constructive interpretation. That's what I mean when I call him a sophisticated formalist. And if the legal realists were not legal positivists, then they would be vulnerable to a Dworkinian reinterpretation of everything they say, and all those judicial decisions would be sophisticated formalist decisions. Now, that's not an argument against Dworkin. The argument against Dworkin is the one that I've given already, but it is a possible way of reacting to the realist critique. I think it's not on. Yeah. Now it's
Okay. Oh, thank you for the talk. It was amazing. My question is, if I understood correctly, which I'm not sure, but it seems that, for example, if you take in one side, in one extreme, the textualist or the originalist, in some sense, they have a clear answer about what is the right thing to do. Well, the right thing is to follow the text of the Constitution. They have an answer for that. And in the other side, you have Dworkin saying we have an objective justice, and the judges, the Herculean judge, should go there and find it, etc. And I wonder, what is the answer of the legal positivists or the realists in this case? Because it seems to me that the answer is, okay, we have to submit to what majority has decided. So, for example, you take a judge that in a very hard case gave a dissent opinion to the majority of the court. He says, okay, the court should not do that. That's not what I ought to do. But I also realize that I ought to submit to the majority, even though I don't believe they're right. It happens with every judge that in a hard case is going to give a dissent opinion, for example. My problem is, and I think that's the central problem, one of the central problems of constitutional law, and in the whole world, in the US and here, how do we pass this kind of logic that it's, as it seems the judges have, like, I ought to submit even though I should not do this, or this is not right? How do we pass this mentality for the rest of society, considering cases that are very hard? So let me give one example, bring the jurisprudence, the constitutional jurisprudence of US. One thing is the problem of abortion, for example. If you don't agree with abortion, and the court decided that this is a constitutional right, you can brag about, you can complain about that, but if you're not agree with abortion, don't do it. That's okay. The problem is, think about the case that happened in the beginning of the 2005 maybe, about the guy that had a cake shop in Denver, and he refused to make the cake for a homosexual couple. And then the case went to the Supreme Court, and the Supreme Court decided that his religious rights should prevail in this case, and he was not obliged to do this. Let's assume that the court would decide otherwise and say to this guy, okay, despite your religious convictions, you have to make the cake because you cannot, that's going to be prejudice to them. In this case, that's going to affect a very fundamental value, a core religious value that this man has. Now, how do I pass this mentality that, for example, a judge has in the Supreme Court of say, okay, I do not agree with this, but the majority has decided I have to abide to it?
Who's the majority that decide? I'm not understanding, because often, right, in that case, they wouldn't say it was a majority, it was a constitutional right. That was not a majority. That was, people who wrote that lived a long time ago. I think I know what you mean, but it's not necessarily a majority.
Okay, I think that the most part of the judges there said this is a constitutional right, but some judges that eventually went otherwise, which I don't know if there was someone in this case, but let's assume that there is a judge that says, no, I do not agree with this. He said, this is not a constitutional right. But at the end of the day, he said, okay, I don't agree with this, but I'm going to submit because that's the decision of the court. That's what the Constitution says. even though I don't agree that that's what the Constitution says. This is a mentality that judges have. My problem is, how do we pass this kind of thing to the common people regarding very fundamental values like religious values? Because if we, in some sense, pass these values to them, this kind of mentality to them, in some sense, we can say to them, okay, this is against your fundamental value, but that's what the majority decides, you have to abide to it. But it seems that people are not willing to do this regarding very fundamental values like religious ones. How do we handle that?
Okay, so there's a lot of things that are there in your question. Let me start with something that's quite basic, but I think very important. Legal positivism is not a theory of how judges should decide cases. It's just got nothing to do with it. All it says, it tells you what are the valid legal norms in a particular society. It's a theory about how we figure that out. It's not a theory about what judges ought to do. Now, judges promise to enforce the law. That gives them a moral reason, right? They made a promise. They took an oath to uphold the law, uphold the Constitution. So they have a moral reason because of that to uphold the law and the Constitution, even if they disagree with it. A legal positivist can have all kinds of moral views, right? A legal positivist can think the law is clear, right? It applies to the facts in this case very clearly, but the law is so unjust that judges shouldn't apply it for equitable reasons. Legal positivists are allowed to think that. Some of them say that, you know. People have gotten confused about this, partly because of Dworkin, because he always treats legal positivism as a theory about how you decide individual cases, which it's not. And also because of Lon Fuller in his famous debate with Hart, the most infamous ad hominem in the history of legal philosophy, says the problem with positivism is you guys made Nazism possible, right? Because all those German judges were positivists, and that's why they did evil things. Well, they weren't Harshian positivists. They weren't even Kelsenian positivists, okay? They were just, you know, they took their oath of office very seriously, and some of them were probably afraid, and so they enforced a lot of very unjust laws. So that's a kind of basic thing. Legal positivism is not a theory of adjudication. Right? Hart himself says in the postscript, he probably should have said more about adjudication. You know? And that was Dworkin in 1975. He said, there are these hard cases. Hart says they just involve discretion. No, I'm going to say we can tell a more complicated story about it. All right, that was the modest Dworkin. As I say, I think he's no longer modest by law's empire. Okay. I don't really have any insight into the kind of sociological question. How do you get citizens to accept the legitimacy of the law, right, and to comply with it, especially when it runs against certain fundamental commitments that they have? Okay. You know, one way governments sometimes do it is with the police and the army, but that's pretty bad if that's what you have to rely on to ensure compliance. Sometimes legal systems will accommodate strongly held religious beliefs precisely because the cost of forcing compliance would be too severe or too harsh. So most, you know, democratic legal systems do create exemptions from the law for those who have religious objections to complying with it. That was the case of our Baker from Colorado. Just as an aside, there were peculiar features of the facts of that case. That is, the Supreme Court thought that on the record of the Colorado Human Rights Commission, people had said things, members of the commission had said things that suggested animus towards religion, dislike of religion, right? And so they thought that this tainted the whole thing. But there are many cases where exemptions have been granted to religious believers and religious institutions, partly because I think of concerns about legitimacy. But as I say, I don't really have an answer. It's a sociological question. How do you ensure the police can't be everywhere? Therefore, there has to be some general level of willingness to comply with the law for society to function. And how do we achieve that? I don't really know. I do know that on Stalin's birthday, people still march in Red Square, bemoaning the fact that Stalin no longer leads them. Right? Stalin was very legitimate for them. This is a little surprising, okay? But it tells you that regimes can be quite oppressive and still enjoy legitimacy. I think the reason Stalin still, some people think warmly of him in Russia and the former Soviet Union, is because things were orderly. Stalin was good at order. Things were orderly, okay? They have a fond memory of that. Now things are disorderly. But as I say, I have no special competence to really answer that.
Brian, let me jump in again. And just to recap something that I might have already started discussing with you, which is Dworkin makes a distinction in Model of Rules 2 between conventional morality and concurrent morality. So conventional morality basically linked to the shared understanding of a value, for example, the value of courtesy. You can have a discussion about the protocol of opening the car's door for a lady is a polite behavior or not. You can check on conventions about that. It could be right, it could be wrong. But he also notices that there's a different kind of moral disagreement when we have concurrent morality, which means that when we have different understandings of how to determine what is right and what is wrong. So, and I think this is very important for us for understanding, for example, the difference between disagreeing whether drinking coffee with sugar is right or wrong, or disagreeing whether torturing criminals is right or wrong. One is a matter of taste. We don't foresee any kind of rational background that could justify why drinking coffee with or without sugar is right or wrong. However, we do acknowledge some kind of background that justifies a rational argument in favor of not torturing criminals. So, and this is a point, I think, and you mentioned that even Hart acknowledged in the postscript that this is a distinction he accepts. However, there he uses an argument that is an empirical argument, which is, oh, this is very rare in society. This is in law. This could happen. Okay, Dworkin made a point here. We could be having a concurrent morality kind of discussion, but this is almost just really rare. So my point is, I think it's really rare because whenever we think about issues concerning, for example, freedom of expression, whether it violates or not equality or dignity, which is a very important constitutional concept here, we have to discuss what is the best interpretation, how should we define these concepts, because they are not well defined in the text of the Constitution. So we have to appeal to some kind of theoretical background, which works, according to my view, very much like this debates on concurrent morality. And if so, don't you think this brings another very important consequence, of course, here in favor of Dworkin's argument?
Good. So I take it protection of human dignity is in the Brazilian Constitution?
Yeah.
It's a fundamental, okay, so like the German Constitution.
Yeah.
Okay. It is there's a question about how are you supposed to interpret moral concepts that appear in legal texts. This is an example, okay? And different legal systems do answer them different ways. You could have what Dworkin himself called a moral reading of the Constitution. That is, if you are confronted with a piece of legislation, part of the code, that it's argued violates dignity, right? You could resolve that by a general moral inquiry into the notion of dignity. Mm-hmm. And in effect, and I'm inclined to say what Raz says about this kind of case, this is a case where the law has awarded to the court a discretionary power. You do some moral reasoning, figure out what dignity is. Okay? The law authorizes this exercise of discretion. Of course, if you think there is a objectively right answer to the question what dignity is from the point of view of morality, then you think you're exercising discretion, but in the service of figuring out what that really is. As you know, I don't think that about morality. But Dworkin, of course, does. The thing is, you can have a jurisdiction in which the interpretation of dignity doesn't really require any moral reasoning whatsoever. Okay. If you're in a jurisdiction that says the intention of the framers of the Constitution determines the meaning of the provisions, then we need to know, what did they think dignity was? That's an empirical inquiry. Okay. If you have a system of precedent, now that doesn't apply here, but it does in the United States, the meaning of moral terms in our Constitution can be settled through interpretation. Everyone, by the Supreme Court, everyone now knows that it is cruel to execute juveniles. No moral inquiry. In fact, the decision in which the Supreme Court held that is notable for not really giving any attention to the word cruel and focusing mostly on unusual. And what the Supreme Court pointed out is that almost no civilized countries execute juveniles except the good old United States. And that's evidence that it's cruel and unusual. And you could have other theories of interpretation that might be binding on the judges, which would preclude a moral inquiry.
But sorry to interrupt you.
No, that's fine.
But don't you think that even the textualist, he has to offer some kind of justification of why textualism is the right way to interpret?
He does.
It does. Is the just? Is the
Correct.
Is the more sound? Or
So they do. So you can ask, what is the moral justification for a particular interpretive approach? Okay, and textualists have an answer to this. There's two main ones that are given in the United States for textualism. One is that the idea that the legislature has an intention is a myth. There is no intention of a legislature. Legislators have many different purposes in voting for laws. Yeah. And the other is that it's more consistent with the rule of law value of publicity and fair notice. Right? People in a free and democratic society should be able to know what the law is without having to do historiography, without having to inquire into, what did this framer think? What did this legislator think? Right? It should be there in the words. That makes the law public, and that's a fundamental value of the rule of law. That's the arguments they usually give for it. But right. When I said textualism is now the orthodoxy in the federal courts in the United States, I think it's now part of the rule of recognition for federal judges, which means they treat it as obligatory, right? So it's not up for, as it were, debate at this point. Now, we could think they're wrong. People have criticized textualism in many different ways. But right now, I think federal judges have an obligation to try to give a textualist reading of any statute.
Yeah, just sorry, but what I mean is that they have to offer some kind of moral justification about why textualism is right. So this kind of effort, maybe more or less developed, more or less explicit, requires some kind of concurrent morality kind of justification. And not cannot be solved in terms of mere conventional understanding, even though, I mean, we of course we explain why it is so well accepted, noticing that there is a strong convention now. Yeah.
Okay. I'm not quite sure what you mean by they have to offer justification, right? If what a statute means is what the plain text of the statute says, and judges have taken an oath to enforce the law, and it's now part of the rule of recognition that the textualist meaning is the binding meaning, I don't think the judge has to give any explanation. Now, many of them have written about it, but they don't have to write about it in their opinion. Right? Occasionally they do. Sometimes there's a dispute breaks out between judges about this, and then they give moral and political arguments why they think this is the better way to read the particular statute. I should say, now I happen to think all morality is conventional. This is one of my somewhat unusual views compared to most legal philosophers. But I think a purely conventional morality is perfectly adequate for justification if everyone accepts the conventional morality, right? If in your community everyone accepts the view that publicity is a value, it doesn't matter whether publicity is really a value. It just matters that everyone here thinks publicity is a rule of law value that's important, and then judges who justify their use of textualist methodology on the ground that this is involved, they've adhered to textualism because of publicity of the law is important, and everyone there will accept that. And we don't have to go much. Now, it's true that there's an ambiguity in conventional here, because even if I'm correct that morality is conventional, I understand that most people, including in America, don't think of morality as conventional. So that they won't think it's an argument in favor of publicity that everyone around here believes in publicity. And then they will try to give some other arguments. And I agree we can have a certain amount of reasoned argument, though reasons run out in moral argument. At some point, you hit rock bottom of fundamental evaluative commitments. So I say textualism because publicity is an important rule of law value. It's only fair to citizens that, that they have notice about what their legal rights and obligations are. And someone else says, who cares about citizens? What matters are only the best, the richest, the powerful. The Symmachus comes along, and now we've hit the value of bedrock. Okay? So moral reasoning runs out. Sometimes it runs out very quickly, sometimes it takes long.
Okay, I think we might have time. Yeah. Okay, we have a question from online. If anyone wants to jump in and make, okay, so we have two questions. So read the question online and then you are online.
So, hi, I'm Professor again. I have a question from Danilo online.
From who?
Danilo,
Oh,
online. Danilo, yes.
Danilo from Harvard?
No, Danilo here from USP.
Oh, okay, there was a Danilo I met at Harvard. Okay.
Professor, you said that although judges often express the intention to resolve cases only with what is determined by law, what they actually think and do is something else. And so we should not take what their opinions at face value. But doesn't the fact that judges actually feel compelled to appear to be ruling only by the law show something in that way? I mean, we can almost never really know what a judge is thinking while deciding. We can only access what judges explicitly say in their opinions. Even your claim about the reason why Roe v. Wade was overruled is in the end only speculation, although a very plausible one. So isn't the fact that judges feel compelled to at least appear to rule only by law a sign that the idea of right answers provided only by law and not by moral or political choices of judges is an important element that must be explained by a legal theory that intends to be accurate? In being so, doesn't that explanation depend on the idea that all use of coercion must be justified by law in some way? And so that any use of coercion must find in law some answer about its rightness or wrongness?
Okay, good, thank you. I agreed with a lot of that up to the point about the exercise of coercion by courts has to be morally justified. I just don't see what that has to do with the theory of law, right? Unless you thought that coercion in accordance with law is generally justified. I don't think we should think that. I think it's an ideological delusion to think that. I think it would be very good to cultivate the idea that the law requires certain things, but they may not be just. They may not be justified. That would have been the attitude that would have been helpful in Germany in the 1930s, and it wasn't their attitude. So I think it is important to distinguish, levels of decision. I think at the Supreme Court, if you take the reasons they give at face value and think you need to try to explain those, I think you're very mistaken about what's actually going on. And I just think it's, here's what a colleague of mine at the University of Texas, another legal realist, used to say. He says, anyone who teaches constitutional law and talks only about law is guilty of educational malpractice. Right? They won't understand what's going on in constitutional law. Right? He wrote a book called The Warren Court and American Politics. It was all about how surrounding political social events explain all the major Warren Court decisions. And it says very little about the law. Lucas A. Poe Jr. is the author, The Warren Court and American Politics. It's instructive about a legal realist approach to American constitutional law. I think at lower levels, sometimes in the appellate courts, certainly in the trial courts, the opinions are worth taking pretty seriously. And that's why it's important for me that legal realism, I think, is most plausible in the appellate courts, but it doesn't apply very well in the lower courts. Why? I think just because the cases in the lower courts are ones that are still taking advantage of the massive agreement about what the law is. And that cases that get into the appellate courts are precisely where the agreement has run out. But I don't think there should be a general principle that we should take at face value what judges say are the reasons for their decisions. It will depend. Okay. You can certainly analyze the reasons, but as in my former colleague Poe's comment about the US Supreme Court and constitutional law, I'm inclined to agree with him that if you talk only about the law and the legal arguments given, you really don't understand what's actually going on. And I'll just mention an empirical result that's related to Danilo's question. It turns out that political scientists who study judicial behavior in terms of the political ideology of the president that appointed the judge, they can do a much better job predicting how judges will vote in cases than constitutional law professors, right? And they don't pay any attention to the law. They can just tell you very conservative, somewhat conservative, moderate, somewhat liberal, very liberal, and they can predict how those judges will vote much, much better than the constitutional law professors. That's some empirical evidence that goes a little beyond speculation, right? That if you want to understand judicial behavior in these higher appellate courts, at least in constitutional law cases, something else is at work other than what the judges write down.
Hi, Professor Leiter. Thank you for your lecture. It's always nice to hear some controversy on Dworkin's work. When I read the title of your lecture, you had me at hello. Yeah, we all know you are one of the most renowned scholars to work on Nietzsche's work, which wouldn't be possible without diving deep into the history of Western thought,
Yeah.
which is something I don't know Dworkin did. But you also said you think Gadamer was essentially wrong on interpretation, which is not the core of my question. The question is, what do you think of Dworkin's use of Gadamer? What do you think is Dworkin's reading of Gadamer?
I think I wouldn't say he has a reading of Gadamer. I mean, it's in footnotes. One or two long footnotes. I think he correctly sees that, loosely speaking, Gadamer's view that what we bring to interpretation always requires certain prejudices. I think he sort of sees that this is sort of helpful for his purposes. But I don't know that it adds up to a reading. I think it was more a matter of trendiness. Everyone was talking about interpretation in the US Academy in the 70s and 80s. I think that's really why he sort of focused on this as a possible way of framing his mature theory after 1975. Everyone was talking about Gadamer, right? So Dworkin sort of, Dworkin is not the only one who tries to attach their views to some currently influential intellectual figure. So I'm not faulting him for doing this, but I think that ultimately is the explanation. But it's only one or two footnotes where he draws this connection. Some people, one Gadamer scholar, actually, a guy named David Hoy, H-O-Y, wrote about this somewhat more systematically, about Dworkin's use of hermeneutics. I remember he was a bit critical, actually, but I don't remember the details. Professor Ronaldo may know this paper. So I would recommend Professor Hoy rather than me on this particular subject.
Okay, I think we have a very rich discussion.
Yeah, great question.
Almost 2 hours. And I'd like just to thank you again, Professor Leiter, for allowing us to avoid a kind of lighter understanding. So your presence here is very fortunate for this reason. And I have to say that I fully agree with you that there's a light Dworkin who is absolutely wrong, and I even and pernicious. I fully agree with that too. And it seems just to make a final provocation. Yeah, just not really a question, but it seems that all that is said and all that you have written about Dworkin shows that the hardworking debate is not finished yet. In
Sadly.
a way, it's premature to say farewell to it. I know you have a conversation with Shapiro about this topic.
Right.
I know, but anyway, I think I'd like to thank you again. Thank you very much. It has been very, very insightful. A privilege, a real privilege to have you here. I hope you will come back soon.
I hope I have the opportunity. Thank you very much for very good questions.
Yeah.